Legal advice. You just don't need it. That is, until you do need it. And CCV have a partner in your corner when you do need it. For over 20 years, Service Industry Advisory Group have been a leading industrial relations, employment law and human resources service provider with specialist knowledge and a proud partner of CCV. Hello and welcome to the Community Clubs Victoria podcast. I'm John Deeks, and along with the Chief Executive Officer of CCV, Andrew Lloyd, we're visiting with Sasha Cook, SIAG Director of Operations. Welcome, Sasha.
Thank you for having me.
Your area of expertise include, in no particular order, award and enterprise agreement interpretation, managing contracts of employment, disciplinary action, termination of employment, dispute resolution, enterprise bargaining, industrial relations and action, payroll audits, and so much more. That's a very broad church. And I'm guessing, Andrew, that most of those might, at one time or another, be an area that affects our CCV member clubs.
Absolutely. There's always some recurring issues and things that we need to assist club leaders and club managers with. The industry is a bit fluid after the pandemic. There's a lot of new managers that come into the industry. As you mentioned, John, SIAG has been a partner with CCV for a long time, provides some great resources through our online portal for managers to download templates and guidebooks and award information. But also SIAG have been fantastic running some webinars and talking to our members at forums about key issues to help support professional development, but also explaining key issues. In the last 12 months, a lot of reform in this space, and I know Sasha will chat to us about that topic today. It's a very tumultuous time in the industrial relations space.
Sasha, you've got a lot of things to have on your plate. How do you juggle them all, and what specifically do relate to our CCV members?
Oh, look, I think the employment law sphere is one which is constantly changing, more so of late, as Andrew said. You know, our role is always to take a practical approach and to really help employers navigate what can be confronting and challenging issues with regard to people management. And I think our job is to assist them work through those processes in an orderly way and manage those risks that can come about from just managing issues with people.
Sasha, I think one of the positive things that I've seen from you and your team is it's not just telling you the law to do with a particular topic. Your staff understand the hospitality environment and what happens in clubs and can relate to that and talk with managers and club leaders in practical terms, explaining things, unpacking them, which I think is so important. You know, some organisations just want to do everything online and say, oh, fill out that template and it'll all take care of itself. We know that doesn't occur. So the advice line that clubs have to ring your advisors and lawyers is really valuable.
The advice line is a really important part of the service. And I think, look, what we certainly bring to the table is that industry knowledge and understanding. We've been in the sector for a long time and our people understand the practical implications of employment law in that hospitality setting. We know what happens, we know the things that can go wrong, and I think we certainly take approaches of demystifying in a way how to apply a set of facts to the circumstances so that you comply with your workplace law obligations.
Are you proactive at SIAG talking to clubs before there are issues?
Yeah, look, we do a bit of both. But to be honest, in terms of the advice line, that's really where it's a first point of call. So it's early on in the issues, or our preference is that's the case, because what we encourage is that managers pick up the phone, give us a call, tell us what the problem is or what the issues are that are unfolding.
Before it becomes a bushfire.
Before it becomes a real problem. We can certainly assist and work those matters through, but it's always helpful if we get in early on and help you avoid some of those issues.
Yeah, that's right. I think coaching of managers is something that's more important going forward, to coach them on not just their practices from a operational point of view with their record keeping, their chronology of things, but also how to deliver messages to staff members and how to manage situations in a thoughtful way, but also a compliant way. Sasha, do you want to talk to us about reoccurring issues that you see in the industry that pop up?
Look, I think The most common one we see, obviously, is what we sort of broadly referred to already, and that is performance and conduct matters with relation to staff. I think that is the most prevalent issue, and it's also one of the most important issues to manage well. We are seeing an increased incidence of both performance and conduct issues in the sector. I'm not sure why that is, but we are seeing increased issues post-COVID.
Such as?
Just an increased prevalence of people not behaving correctly, people not complying with reasonable and lawful directions, general conduct issues that could go to... Do you have any
thoughts as to why that might be?
Look, to be honest, I'm not quite sure of the psychology behind it, but all I can say to you is there's definitely an increased level of issue. I'm not sure if people are taking the perspective that work is secondary, more so than it was previously, and in those circumstances are simply not doing the right thing.
From a psychology point of view, we have had organisational psychologists saying don't underestimate the flow-on effects from the pandemic in Victoria. The psychology behind it, a lot of people say that there's more road rage, people short-tempered to do things. So I think there's definitely some flow-on effects that affect workplaces in the changing environment that we live in.
Sasha, what are some of the top 3 or 4 whatever issues that are just a constant coming back to SIAG to resolve or to investigate?
Normally we'll have conduct and performance issues. That's probably the top issue to deal with, and that can be any range of matters. That can include theft, that can include sexual harassment, that can include just standard non-compliance with reasonable and lawful directions. Other issues we see coming to the fore, issues of compliance in terms of the pay rules that are instituted in the pay systems. Are they compliant with the award requirements? That's certainly an increasing issue. We get more and more queries with that. And then flowing from that, what do I do to fix it? If I identify a problem, and we certainly take the clubs through that process as well, which includes notification to employees, rectification in terms of payments, and also systems rules rectification. Other issues, broadly, we have impinging factors like obligations associated with work health and safety. What are my duty of care obligations? How far does that extend? What are reasonably practical measures to manage risk or hazards? Those are some of the things that come through. We also have probably the newer issues associated with casual conversion. What do I have to do? What do the new laws say?
The casual conversion, SIAG do some great bulletins, and sometimes you read the bulletins and say, can we plain English that more? Because you've got new managers coming into the industry that may not have done workplace relations, human resource subjects in even TAFE or higher education in universities. I think those bulletins are great. Sasha, do you just want to put your coaching hat on and tell us what you think is probably the most effective way to implement effective HR policies in a club workplace?
Okay, well, you've got to have a good suite of policies to start with that address the core workplace law obligations. The CCV website has just that suite of HR policies and procedures. We also review and update those suite of policies where there are legislative or workplace practice changes. And in terms of implementation of those sorts of arrangements, it's important that there needs to be communication with employees at the induction stage in terms of introducing them to the suite of employees so they know and understand both their rights and obligations which arise under those instruments. There does need to be a degree of regular training associated with those policies as well. And that does differ dependent on the matter, as I said, sexual harassment, a little more regular. And certainly then it's also an overall assessment, which is things like workplace culture surveys and really touching base to ensure that you're satisfied that people know and understand and are complying with their workplace behaviour standards that arise from those policies.
And that's where the suite of policies and the handbooks, I think, come into play. Sasha, in anything when it becomes a legal environment, evidence is important. Do you just want to talk through for managers probably some good practices to do with managing information? There's a conflict or there's a disagreement. At the end of the day, evidence is very important to have a trail to demonstrate what the club, the organisation has done, but also from the employee's point of view, what's actually taken place.
Yeah, it's a really good question, Andrew. And in terms of advice that we give in this space, it's always can't over-document. I think keeping a contemporaneous record of any conversations that you've had, certainly documenting any complaints, issues, concerns, extremely important. And I think the documentation also extends to where you are addressing an issue, put it in writing. We can give advice, obviously, as to what that needs to include in terms of its form. Be clear on the facts, though. What's the information before you? Have you documented that? Have you included that? And then also including relevant material about what is the process, what are the steps, and what are the consequences in terms of any decisions that might be made or any findings that might be made as this process progresses. So I think it is really stepping people through each step along the way to make sure that everything is documented correctly and addressed in the proper form so that you can rely on that at the end, so that your decision-making process is very clear and it's based on balance on credible material before you. I can't emphasise enough how important documentation is.
Things like induction plans and staff handbooks, those types of things. In my own experience in dealing with club managers, that's really a paramount thing that not enough people, I think, put into place and review constantly and talk with yourself and your staff, Sasha, to make sure it's all fit for purpose. And because every club is a little bit different to do with its operations. You might have a bowling club, a golf club. A lot of things are common, but then there's also points of difference out there as well.
Look, I think it's the same as anything, though. Documentation just weaves its way through everything. You know, if you want to assert a particular fact, having documentary evidence of that is extremely helpful. If you've agreed to something, having documentary evidence attesting to that is extremely important. That can be a contract of employment, that can be all sorts of things. But again, it all goes back to the central importance of having documentation.
Sasha, can you just talk to us about the new laws to do with right to disconnect? There's a lot of misconceptions out there with managers but also staff members.
Yeah, okay. So the premise of the legislation is that employees have a right to refuse to monitor, read or respond to contact or attempted contact outside their working hours unless doing so is unreasonable. Importantly, this includes contact or attempted contact from an employer or a third party. That's the premise of it. And then you've got to look at, but there are nuances in terms of how work occurs in a club setting, for example. That would mean that you are not precluded from contacting employees in every circumstance. That's not what the laws are designed to do. And there is that threshold parameter that there can be that refusal unless it's unreasonable to do so. If I take, for example, someone whose employment includes that they're on call, okay, so obviously they are compensated and that there is a default presumption that it's reasonable that they be contacted because that's the very nature of that on-call arrangement. In a club setting, that might be maintenance people and things like that, or greenkeepers that might have the need to come in for after hours and things like that. So there's existing arrangements were in place that recognise there can be contact in specific circumstances. It's also things like you might be contacted for acceptance of a voluntary shift if you want to pick up some additional hours. The employer's not precluded from contacting you in those circumstances. You don't have to respond, but they're not precluded from contacting you in those circumstances. There's a lot of talk about these new workplace laws, but in practice, some of the things that meant that it was reasonable to contact people and circumstances where there would be an expectation of response continue to operate.
Sasha, if some staff member takes umbrage and wants to escalate the issue, how would an employee actually go about it? Would it be a general protection application to Fair Work?
I think it's more just a dispute process through the FWC. That's really what you're probably looking at in most circumstances. Look, the intention is to try and resolve these issues without problem. You can have orders from the Commission in those circumstances to stop the contact and things like that. The intention is really that these be worked through in an orderly fashion, and if that's necessary, it can go through a dispute process in the Commission.
Does SIAG assist government in forming policy?
We are not a lobbying group, and we leave those duties to CCV.
Clubs Australia, on behalf of the state and territory club associations, do submissions to government, and we discuss with Sasha and her team different aspects of those submissions to make sure that they're relevant and reflect what's happening in our state, our jurisdiction, and that's always important, the work that Clubs Australia do in this space. Sasha, I just wanted to ask, respectful workplace behaviours comes up in the media to do with things that occur in workplaces. I know you've run some of these great little seminars for organisations and clubs previously. Talk to us about how important that training is for people in a workplace.
Look, I think it's really important. It's not just about societal expectations, but there are workplace laws with relation to sexual harassment. If you meet the definition, obviously that constitutes under the Act now serious misconduct. It can lead to the termination of one's employment. It's not only essential because if you fall foul, it can lead to very serious consequences, but it is about a harmonious, respectful workplace. Fundamentally, you want people, whilst it might be a friendly workplace setting, and clubs often are, there's lots of people interaction, whether that be with colleagues or whether that be with the customers, but it also is a workplace. So those interactions need to be respectful, they need to be professional, and they need to be appropriate.
And understood.
Absolutely. People need to know and understand, like I said before, rights and obligations. You have an obligation to conduct yourself in a professional and an appropriate manner, and you also have the right to enjoy a workplace that is free from inappropriate or harassing or sexually inappropriate behaviour. Those are basic obligations and rights, and certainly I think any workplace works better when those sorts of things are instilled. You know, often the feedback I get on this one is, oh, you can't say anything anymore. But look, that's not true. But you do need to recognise it's a workplace. It's not a nightclub. It's all got to be professional.
Sasha, one of our staff, Blake, is attending the HSR, the Health and Safety Representative Training course, which I think is excellent. And we want more clubs to think about putting staff through that course. Can we just talk about that for a minute? Health and safety. I know there's been changes in recent times to do with the legal responsibilities.
Look, I think getting back to sort of the core here, employers have a duty under OH&S legislation to provide and maintain a workplace that's free from risks to health and safety as far as reasonably practical. So there are a number of considerations as to what constitutes reasonably practical. Got to have consideration of the likelihood of a hazard, the risk, the potential for resultant harm, you know, what measures are available, the cost of those measures to manage or mitigate risk. So all of those factors are considered in the context of the prevailing circumstances. But what it turns on is there is a clear presumption in favour of safety. You have an obligation to provide a safe workplace. And in those circumstances, look, there are a number of things that flow from that. That includes, you know, basic things like reporting incidents, having clear policies and procedures in relation to occupational health and safety, doing good things like having HSRs trained so that they know and understand and can implement the initiatives in relation to workplace safety. You've got to monitor compliance, audit the workplace in that way as well. You've got to keep good records. There are various matters that come up in relation to health and safety. It's the same as employment. There are so many impacting things that you've got to think about. But in the club setting, obviously, workplace violence is always a big one to consider. There can be awful circumstances which can arise in terms of violent episodes that can occur in the workplace, whether that's a break-in, whether that's aggressive patrons, whether it's, some kind of workplace episode that occurs. So there's a multitude of things that need to be considered. That's probably one that comes to mind as a key one that sometimes gets forgotten because it is a little bit worst case scenario, but is a really important one to have in your stable in terms of training, policy, and just dealing with that, not just after the event, but being proactive about it.
In the old days, we had our ring binders with all the policies and procedures available for the staff. In recent years, everything's just online. I'm a big believer that we still should have those ring binders with all that information available for staff, and they should have copies. They should know what's in the policies because everyone's just watching their phones. Do you agree with that?
Well, I think that's a really important aspect, though. It's looking at your staff, okay? So looking at the dynamics of your workforce and what is the method which is going to ensure that all those staff know and understand and have access to those key policies and procedures. Because it's all well and good to simply say, oh, it's on the intranet or it's available via this, but no one looks at it. No one really reads it. No one's aware of it. So, look, it's a combined approach. I think it's not only, what is the medium upon which that's made available, and that's got to be in recognition of the workforce that you have before you. Do I think it's positive to have it in electronic form and in hard copy form? Yes, I do. It's not a waste to have that because it improves accessibility. It recognises that you might have a diverse mix of employees and some people are not as comfortable as others with various electronic devices. What you want to do is make it as available as possible to ensure that as many of your staff as possible have access. That's really important.
Sasha, in the past, I remember a conversation with one manager who just said, oh, can you just find us a part-time HR manager? I don't want to have to deal with any of these issues. I just want this great, efficient lady to just manage everything. My advice to that manager was, you can't just outsource this. This your staff, it's your workplace. You need to lead it. You need to manage it, was my perspective. But do you get that from clients from time to time?
Yeah, and I think, look, it is this elusive person that will solve all problems, some miracle worker that is the repository of all knowledge and experience as well. That's pretty tough art. It also goes against what you're talking about as well, which is taking responsibility, having ownership, having knowledge and understanding. You're not expected to be an expert in the HR space though, okay? So you're expected to manage employees, to deal with them appropriately, but that's why you have a partnership with SIAG, because we are experts in this space. That is what we are engaged to do. So what we bring to that is having that capacity to engage with those managers on the particular facts that are before them, applying it in a practical way to the law and really giving them guidance on, well, what do I do now? Can you help me? Can you take me through this? And I think that's what we're there for. That's what we do on a day-to-day basis.
Sasha Cook, thank you so much for spending time out of your very, very busy day to help member clubs understand what it is and navigate those difficult legal questions and so much more.
I've really enjoyed today, so certainly thank you both for having me today.
The CCV, along with SIAG, have your clubs back.
Absolutely. That's why we have this enduring partnership, and we're very grateful for Sasha and her team's assistance to our members.
Well, I hope you found this podcast of interest and you'll join Andrew Lloyd and myself again next time. Thanks for listening.